Everyone. Welcome to today's webinar. Again, my name is Jason Q. I'm a staff attorney at the DC Bar Pro Bono Center. Today's session is Keeping Your Story Straight, a webinar for taking minutes for nonprofits. This event is part of our ongoing Board Basics series, where we discuss common operational issues that are faced by nonprofit boards, everything from calling board meetings to taking votes to running your board committees. I encourage you to check out the other resources that we have on board governance, and I'll have a link to those resources on the last slide of today's presentation. A couple more housekeeping matters. First of all, there's a function in GoToWebinar that will allow you to submit questions during the webinar. We'll try our best to tackle as many questions as we can during the presentation and at the end. Second, we'll be sending out an online feedback form for this webinar in the next day or so. We ask that you please take a minute to complete the survey. We really do value your feedback and any suggestions you might have for future events. We'll also attach a link to today's slides with the survey. You can also download a copy of the slides through your GoToWebinar client. Just look for the handouts button. Okay. So a little bit more information about the sponsors of today's webinar. We are the DC Bar Pro Bono Center. We match nonprofit organizations with pro bono legal counsel who help with many different types of legal matters, including corporate governance, IRS compliance, employment law, real estate matters. We also host in-person legal clinics where nonprofits can meet face-to-face with attorneys to tackle specific issues such as their governance policies, their risk management practices, intellectual property. We also sponsor trainings, webinars, and podcasts. And finally, we provide written resources and archive training sessions on our website. The address is www.lawhelp.org/DC/CED. Okay, so here's a roadmap for today's webinar. We'll start by talking about why keep minutes, what functions do board minutes serve. Secondly, we'll talk generally about how we should take the minutes and what our minutes should look like. We'll talk about minutes for committee meetings and executive sessions. And then we'll dive into some special situations where there are more detailed requirements for your meeting minutes. So those are approving conflict of interest transactions, setting executive compensation, and whether or not to grant board indemnification. We'll talk briefly about actions taken outside of board meetings and the record-keeping requirements for those. And then finally, we'll touch on the record retention requirements for your meeting minutes. Okay, so why do we need board minutes? There's four big reasons why you need to keep board minutes. The first is because of legal compliance. Nonprofits are required to keep minutes under DC law. Here's the language from the DC Code. A nonprofit corporation shall keep as permanent records minutes of all meetings of its members, board of directors, or any designated body. They must also keep a record of all actions taken by these entities. So there's the language in the code. The IRS also asks if your organization keeps minutes of board and committee meetings on Form 990. For the IRS, this indicates that you have effective management controls in place. Poor governance practices, like not keeping minutes, can affect your organization's audit risk. So the second reason why you need to keep your board minutes is to document your corporate actions. When an officer or an employee takes any action on behalf of the organization, the minutes are what document that the board has authorized the individual to do so. So something a lot of organizations will do is they'll try to open a bank account in the name of the organization. If you do that, the bank will want proof that the individual has permission to open the account, and that process for authorizing that action would be recorded in your minutes. The third reason for why you need to keep your board minutes is to document the performance of your board functions. The minutes demonstrate that the directors are exercising their fiduciary duties with proper care. Under DC law, directors have fiduciary duties of care, of loyalty, obedience, and a duty to inform. So it's your minutes that provide an important paper trail documenting that the directors are acting in accordance with these duties. For example, regarding the organization's annual budget, your minutes would state that the treasurer presented the budget in detail to the board for review. They would document that the directors properly reviewed the budget, and they would document that the directors asked questions about the budget. These would all be indicia that the directors are acting within their duty of care to the organization by exercising financial oversight. So that's one example where the minutes are providing that background documentation. And the final reason that we need board minutes is that they document that you're properly handling sensitive situations or transactions. In the case of any related party transaction, the minutes document that the board followed all the appropriate steps for approving the transaction. So let me give you an example, but we'll dive into these in greater detail. Let's say, suppose that your organization was considering hiring a company to perform some work, and the company was owned by the spouse of one of the directors. The minutes for this meeting would document that the director disclosed the potential conflict of interest and then left the meeting, that the board reviewed the transaction and alternative options to determine whether it was still the best deal for the organization and otherwise would be in its best interest, and that the transaction was approved by a majority of the disinterested directors in a vote. So as I said, we'll cover these special situations in more detail, but there are situations where your board minutes provide a very crucial paper trail documenting that the board followed the right procedures for approving certain highly scrutinized or sensitive transactions. Okay, so let's get to the mechanics, how to take minutes. Our first big message is that your minutes should be succinct. Let's keep in mind that the minutes serve a specific function. They are there to show that an action was authorized by the board and that the board exercised due care in carrying out its duties. They should give just the basic information necessary to serve this function. Conversely, the minutes are not intended to be a transcript of the meeting. They're not intended to be a history of the organization or a public document. And you should keep in mind that minutes are discoverable if you are sued. So do not record your meetings. Don't include too much detail. And let me go back to that point about the minutes not being a public document. We've come across a lot of organizations who think of their minutes as a way of enhancing transparency or as a way of communicating with the public. But this is very risky and not something that we recommend that organizations do. If your board is engaged and effective, there will often be sensitive or confidential topics that come up at your board meetings. These shouldn't be subject to public scrutiny, and the directors might be less willing to engage in robust conversation if they know that the minutes will be publicly disclosed. So while transparency is good, the board needs the space and the latitude to perform its core functions. So we're always balancing those two considerations. If you do want to be transparent about what's happening at your meetings, you can provide a public summary of the meeting, or you can provide a summary of the agenda items that you covered, but don't just stick your minutes on your website. That's a bad idea. Okay, so let's go back to taking the minutes. There's no specific format that the minutes have to take. They have to be in writing, but the document can be hard copy, it can be electronic copy, it can be part of an email. There's flexibility there. However, there are certain pieces of information that must be included. So you must include the name of the organization, the date, the time, and the place of the meeting, which board members were present and which were absent. And we're noting here that members attending via conference call are considered present at the meeting, who called the meeting to order and who kept the minutes, all motions made and the results of all voting, and finally, when the meeting ended. A director's vote should not be recorded by name unless the director asks that it be so recorded. So let's go look at some sample minutes to tie this all together. Here we have the board minutes for the Very Helpful Nonprofit. At the top of the minutes, we have a list of who's present, who's absent. We have a note of what time the meeting was called, the chair called the meeting to order. We have a note that the quorum was present for purposes of conducting the business of the corporation. And then we have our first agenda item, approval of the minutes. So the board then reviewed the minutes of the previous meeting, which are attached as an exhibit. A motion to approve the minutes was made by Jane Doe and seconded. There being no further discussion, the motion was passed unanimously. So that's a pretty straightforward one. Let's look at another agenda item here. review and approval of the budget. So the chair then recognized the treasurer for the purposes of approving the fiscal year budget. The treasurer reviewed for the board the projected income for the year and the specific sources of such funds and the projected expenses. The treasurer then stated that the finance committee had also reviewed the proposed budget in detail and recommended its adoption. The chair then opened the meeting up for questions. Following the questions, the treasurer moved that the budget be adopted. The motion was seconded. After discussion, the question was called for a vote, and the budget was approved by a vote of 7 in favor, 2 against, with 1 abstention. All right, so these are good minutes. They're performing their core function, which are 1, to record the fact that the board voted and approved the budget, and 2, to show that the board exercised its duties as part of this process. You know, it listened to the treasurer's report, the directors asked questions, there was a discussion about the budget, so we know that the board was engaged. But at the same time, let's note what isn't here. We don't have a transcript of the meeting. We don't go into a deep dive of the specific questions that were asked. We don't have something like, Sally made an argument about X budget item to which Jim responded with Y. We don't have all those details. Having that extra layer of detail isn't necessary for the minutes to serve their function and would expose the organization to unnecessary risk. And including all that factual kind of he said, she said in the minutes can open you up to factual disagreements. Then you have board members disagreeing about whether the minutes were accurate when you never needed to have that kind of detail, that kind of information in the minutes in the first place. So keep your minutes simple, keep them brief. I like to think that the minutes should be a record of what the board did and not what the board members said. Could be a useful framework for thinking about it. Okay, so let's go back to some mechanical considerations. Who should take the minutes? Someone should be designated to take notes at the meeting. It doesn't have to be the secretary. If you ask someone else to do it, that person is called the recording secretary. Under DC law, the secretary does have the responsibility of overseeing the process for preparing minutes. The secretary or the recording secretary's notes help in the preparation of the minutes. You should keep the notes until the minutes are prepared and approved by the board, usually at the next meeting. Then make it a practice to destroy the notes systematically. Don't wait until your organization is sued or investigated. Then you can't destroy your notes. Okay, when to prepare meetings. So the IRS wants your minutes to be prepared contemporaneously. So on Form 990, the IRS asks specifically if the minutes were prepared within the later of 60 days or the next board meeting. This is the IRS's definition of contemporaneous. So you get either 60 days or the next board meeting, whichever one is later. But it is the best practice to complete your minutes as soon as practical after a meeting. Per the IRS, non-contemporaneous minutes will be given little or no evidentiary weight when trying to prove that the organization acted appropriately. So for example, when approving a conflict of interest transaction, as we'll talk about later. Okay, so what about committee meeting minutes? Let's do some background. The DC Nonprofit Code provides that there are 2 types of committees. There are advisory committees, which don't have the authority to act on behalf of the board. Usually they can just issue non-binding advisory opinions. And then you have board committees. A board committee can exercise the same authority as the board in its subject area. So for example, the finance committee or the executive committee will typically have the authority to approve changes to the budget without requiring further board action. That committee has all the powers of the whole board in its specific subject area. So here's the rule. You should take minutes of all board committee meetings. You should do so even if no board type action is taken at a particular meeting. Because board committees exercise the same authority as the whole board, you should take minutes of those committee meetings just like you would a full board meeting. Okay, and what about executive session minutes? So as a refresher, executive sessions are meetings or portions of board meetings at which only the directors and possibly a limited number of staff are present. A board is entitled to meet in executive session. It should do so when discussing confidential or sensitive matters, such as personnel matters. Executive sessions allow board members to have frank and open discussions without the presence of staff or members of the public. They're a useful tool for the board. A lot of people think that you don't have to take minutes for executive sessions, and that's not true. You are required to keep minutes of executive sessions in the same way as open sessions. In such cases, there will be two sets of minutes, one set for the open session and one for the executive session. They should be kept and stored separately. The way that this would usually work is that in your open session minutes, you would have a note saying, and then the board went into executive session. And then you would have a separate set of executive session minutes that record what happened in executive session. And then back in your open session minutes, you would say, and then the board came back from executive session. And then you would continue with the meeting in those minutes. Mark the minutes and all the documents that you distribute for review during executive sessions as confidential and limit their circulation. Don't widely disseminate them to maintain the confidentiality. You should take extra care to avoid recording more detail than is necessary. As we've said, that should be your practice generally for all of your minutes, but especially because executive sessions can often involve confidential or sensitive matters, you should be particularly diligent to not record more detail than necessary. And you should talk to your attorney about how you record and store your executive session minutes. This is a very sensitive area, so something to be extra thoughtful about. Okay, so now we're going to turn into our special situations. We talked about the general rule, which is to keep your minutes succinct and not to go into too much detail. But there are special situations where record-keeping requirements are more specific and more detailed. Let's give the legal background just to set that up. Under the Internal Revenue Code, a nonprofit organization must use its assets for the exclusive benefit of the organization's charitable mission, and not for the private benefit of insiders. If a nonprofit violates the exclusive benefit rule, it may lose its tax-exempt status. So insiders here can include officers, directors, high-ranking employees, and their families. In addition to the loss of exempt status, any insider who receives a financial benefit from the organization that exceeds what the insider gives in return is subject to financial penalties, as are other insiders who approve the transaction. So for example, if an insider sells a building to the organization for a price that exceeds its fair market value, that individual can be subject to financial penalties, as could the other board members who approved that sale. So the takeaway here is that when we have these private benefit issues, it's an area of IRS scrutiny, and the IRS has special penalties that it can exact. So these types of scrutinized transactions can include approving conflict of interest transactions. It also includes approving executive compensation and authorizing the indemnification of directors. So those are three areas that we're going to talk about in depth. In each of these situations, the board must follow certain steps in order to properly approve the transaction. If the steps are not followed, the approval may not be legally valid. And then the rules surrounding board minutes are more specific in these situations. The minutes should reflect in detail that the proper procedural steps were taken. Okay, so let's go to our first special situation, conflict of interest transactions. So a conflict of interest transaction can be any transaction involving the nonprofit and an officer, director, key employee, or the family members of those individuals. Under IRS and state law requirements, nonprofits should not engage in a conflict of interest transaction unless the person with the conflict discloses his or her interest, the transaction is in the best interest of the nonprofit, and it is approved by a group of disinterested directors. The management of conflict of interest transactions must be documented in detail. So that's where your minutes come into play. The board should create a record demonstrating that the required steps were taken, which include the following: the name of the person with a potential conflict of interest and the nature of that interest, the board's decision as to whether a conflict of interest actually existed, the content of the board's discussion, including of any alternatives to the proposed transaction, the names of the persons who were present and absent for the discussion and the votes relating to the transaction, and a record absent for discussion and voting, and a record of any votes taken in connection with the proceedings. So your nonprofit should have a conflict of interest policy that codifies its process for managing conflict of interest and that codifies these record-keeping steps. Your conflict of interest policy can sort of be a roadmap or an instruction manual for the organization when these situations come up, of the steps that your organization takes. So let's look at some examples. Actually, at the beginning of the presentation, we had an example of a conflict of interest transaction. It was when that nonprofit was thinking about hiring the company that was owned by the spouse of a director. That was a brief example. This is going to be a bit of a more detailed example. So we have the approval of a building purchase. The chair then recognized Jane Doe, the chair of the site selection committee of the board, for the purposes of discussing the purchase of a new facility. Sorry, that's John Doe. Before the discussion began, Regina informed the board that she had a 50% ownership interest in the building. Because the board determined that there was a conflict of interest, Regina left the meeting and did not participate in the discussion or vote. So here in the first paragraph, we've already got the name of the person with a potential conflict, and we have the board deciding that there was in fact a conflict. Okay, so then John then reviewed for the board the process for recommending Regina's building for purchase. He stated that the site selection committee had looked at 5 buildings in the neighborhood with attached Exhibit C. He stated that the committee used 4 factors when deciding which building to recommend: cost, size, condition, and proximity to public transport. He stated that Regina was not present for any of the committee discussions and that the committee had Regina's building appraised by an independent appraiser who said the asking price was fair. John then stated that Regina's building scored highest in terms of cost, condition, and size, and second highest in terms of proximity, as again set forth in Exhibit C. He then stated that the site selection committee recommended that Regina's building be purchased and that the price at the price determined by the appraiser. So here we have a relatively in-depth description of the board's decision-making process. We know what kind of information the board considered, what the various factors were, and we also have an attached exhibit which presumably includes a lot more of the factual detail. You wouldn't go into this amount of depth for regular board minutes, but because this is a conflict of interest situation, we have to give all those facts. Okay, and then the chair then opened up the meeting for questions. After answering the board's questions about the building and the process used, John moved that Regina's building be purchased at the terms set forth in the independent appraisal. The motion was seconded. We have a list of the people who are present for the vote. 8 members voted in favor and 1 abstained. So you can see here that these minutes are much more substantive. We're creating a paper trail to show that the board engaged in a robust and detailed review of the transaction and that it independently concluded that Regina's building was the best choice for the organization. Now, if someone were to say, oh, you only chose to buy that building because one of your directors is the owner, you can point to all the steps that the organization took to back up its decision. But note that a lot of our basic rules still apply. This isn't a transcript of the meeting. It doesn't go verbatim into what the questions were or whether there was back and forth between the directors. We're providing just enough information for the minutes to serve their function and no more. Okay, so that was conflict of interest. Let's go to our second special situation, which is executive compensation. So the IRS is particularly concerned that nonprofit executives do not receive excessive compensation. In order to ensure that executives receive appropriate compensation, the IRS encourages nonprofits to use the compensation safe harbor set forth in the Internal Revenue Code. If the nonprofit uses the safe harbor process, the burden will be on the IRS to demonstrate that the executive compensation is excessive. If the safe harbor is not used, it becomes the nonprofit's burden to show that the compensation was not excessive. So this kind of burden shifting provides the nonprofit with a good level of protection, of insulation, if you were to come under scrutiny. On Form 990, the IRS actually asks if the safe harbor was followed. Okay, so let's talk about the safe harbor. The safe harbor requires that the compensation must be reviewed and approved in advance by the board or a compensation committee. The board or committee must base its decision on compensation data for similarly qualified persons in comparable positions at comparable organizations. The board or the compensation committee must document its decision contemporaneously. That's where the minutes come in. In addition, the compensation must be properly reported to the IRS. This contemporaneous documentation must set forth the terms of the compensation approved and the date approved, the members of the board or committee present during debate and those who voted, the comparability data relied upon and how that data was obtained, and any actions taken by members of the board or the committee who had a conflict of interest with respect to the transaction. So the sort of theme here is similar to what we saw with the conflict of interest. We need to document that the board went through a proper procedure for approving the compensation, and that for people with conflicts of interest, so maybe the person whose compensation we're voting on, or people who have a personal relationship to that person, we need to make sure that they properly disclose their conflict and, if necessary, were excluded from the conversation, from the discussion. Well-drafted meeting minutes would satisfy this contemporaneous documentation requirement. Okay, and then we have our third special situation, which is board indemnification. So some more background. In the event that a director is sued because of his or her service on the board, the director may be entitled to indemnification. Indemnification means that the nonprofit will reimburse the director for any expenses he or she incurs because of the lawsuit, including reasonable expenses and attorney fees. DC law requires indemnification where officers or directors are successful in defending a lawsuit arising from their position with the nonprofit. It's called mandatory indemnification. But a director can also be eligible for non-mandatory or permissive indemnification in other circumstances if they acted in good faith and for a purpose that they reasonably believe to be in the best interests of the corporation, of the nonprofit. In the case of criminal proceedings, the director also cannot have had reasonable cause to believe that their conduct was unlawful. Your nonprofit's policy regarding permissive indemnification should be defined in its bylaws. So look to your bylaws and see if they address this permissive indemnification. Procedurally, the decision of whether a director is entitled to permissive indemnification is made by the directors who do not have an interest in the decision, and it's made on a case-by-case basis. As with any decision where the directors have a potential conflict of interest, there must be a record demonstrating what steps were taken during the decision-making process, including the name of the person seeking indemnification and the reason why, the names of the persons who were present for discussions and voting related to the transaction, a summary of the content of that discussion, and the board's decision as to whether the director is entitled to be indemnified, and a record of the actual votes taken in connection with the proceeding. So how this might work is, let's say somebody sues the nonprofit and a board member for allegedly breach of contract. So in this situation, you might want to cover the director's legal expenses related to defending the lawsuit. The director isn't entitled to the mandatory indemnification because that only kicks in after they've successfully defended the suit. You might want to provide indemnification starting from the beginning of the legal process. In that case, the directors have to get together, they have to discuss, and they have to make their own determination, first and foremost, that the director was acting in good faith and under the reasonable belief that they were acting in the interest of the nonprofit. But there might be other considerations as well, like can the nonprofit afford to indemnify the director? Is it covered by insurance? Are there other reasons why you wouldn't want to provide the indemnification? So the minutes of the meeting would be used to record the substance of these discussions, and they would be used to support the board's ultimate decision whether or not to grant the indemnification. Okay, so our next topic is about actions taken outside of a meeting, so unanimous written consents. Let's go. The background rule is that a board can only act at a duly called board meeting for which proper notice was given and at which a quorum is present at the time of the vote. But there is one exception. If directors are unable to meet in person, as above, DC law and your bylaws can allow for actions to be taken via unanimous written consent. The consent must be in writing, and it must state the name of the nonprofit, the action being taken, and the effective date of the resolution. It must be signed by every director then serving on the board. So for example, if there are 9 people on the board, it must be signed by all 9 individuals. It's not enough if 7 sign and 2 just don't respond. Unanimous means unanimous. A record of the unanimous consent must be kept, and it should be stored with the minutes of the organization. Include copies of all the responses from the directors. A unanimous written consent is an action that's taken by the board, so there must be a record of that action. Electronic signatures are generally acceptable in DC, so you can do your unanimous written consent over email. But the signature on a director's written consent must be identifiable to a specific individual and tied to a specific action. So for example, we can have an email from me, from my email address, jqu@dcbar.org. I consent to the proposed action sent forth in this email. The resolution is attached, and we have my full email signature there. So you can tell from this that this is me, and you can tell what specific action is being referred to. What wouldn't be acceptable is just an email from jcool@gmail.com just saying, fine by me. A third party looking at this email couldn't be sure that this was actually me speaking, and they couldn't be sure what specific action we're talking about. So you can do your unanimous written consents, through writing or through email, but just make sure that all the directors are identifiable. Okay, so now let's turn to record retention requirements for your minutes. So DC law requires that the minutes of board meetings be kept permanently. Include with the minutes any attachments or exhibits that you reference in the minutes, your reports, your comparability data. Minutes should be stored in a central location and not in the personal files or on the personal computer of a board member or a staff member. We have had many situations where individuals have left organizations or they've left the board, and suddenly access to the minutes has also disappeared and they can't get back in contact with that person. You have a responsibility to keep your board minutes permanently, so make sure that they're stored in a location that can be accessed permanently. You should keep backup copies. Paper copies should be stored in a fireproof file cabinet. Electronic copies should be backed up on the cloud. Again, make sure that more than one person has the username and password. Finally, as a best practice, your nonprofit should have a record retention and destruction policy. The policy should identify documents by category and list how long they should be retained. Once a document has served its purpose, it should be destroyed. And your record retention policy is where you can codify the fact that your board minutes are meant to be kept permanently. Okay, great. So that's the end of substantive presentation. We can move on to questions. Make sure to go to GoToWebinar if you want to submit your questions. Here's my contact information. My email address is jqu@dcbar.org. Again, if you have questions that you didn't get a chance to ask here or that you want to ask after, feel free to just email them to me. I also want to highlight again our website. It's www.lawhelp.org/DC/CED. And we have a special section on that website called Serving on the Board of Directors, which collects all of our board governance resources. You'll find information there about a lot of topics that we've talked about today. So about executive session, we have documents on that. We have information about indemnification. We have a lot of resources on managing conflicts of interest. So if there's anything that you heard today in the context of talking about meeting minutes that you want more background information about, you should definitely check out that section of the website. Let me take a look and see how we're doing for questions. Give me a moment. Okay, let's see here. Okay, somebody asked about the slides for the presentation. You can probably download them through GoToWebinar if that's what you're using to sign in today under the Handouts tab. We'll also email out, through the control panel on GoToWebinar. We'll also email out a link to the slides with the feedback form, and we'll also post this webinar and the slides on our website, on the Law Help website, in the next few days. So just make sure to check back there. Okay, let's see here. Does the law specify what is proper notice for a board meeting? Like how far in advance? What form should the notification take? That's a great question. There are notice requirements under the DC Nonprofit Code. We have a resource on Law Help in our Board Basics series all about the notice for meetings. So I'm going to point your attention there. And then if you have additional questions, you can email me and we can discuss those. But yes, there should be notice requirements. And a lot of those details can also be addressed in your bylaws about how your specific organization provides notice of meetings. Let's see. Okay, so one person is asking, just to confirm, should votes on motions not be recorded by name, just unanimous or, X in favor, X number against? Yes. So unless a director specifically requests that their vote be recorded by name, the results of voting should just be recorded as X number of people voted in favor, X number of people voted against, X number of people abstained. That's right. That's the best practice. What happens to the minutes if a nonprofit is dissolved? So it's even after dissolution, it would still be a good idea to keep your minutes through the dissolution process and after, just because there could still be actions involving the nonprofit that come up after dissolution. Someone could still sue the nonprofit, or there might be ongoing issues that the nonprofit has to tie up. So we would definitely recommend keeping your minutes for as long as practicable, really, after the nonprofit is dissolved, just in case you need to refer to your minutes in some sort of defense or some sort of proceeding that involves the nonprofit. But when the nonprofit is dissolved, you don't have the obligation to keep ongoing minutes. But as a prudential sort of consideration, do your best to keep your minutes through the dissolution process for as long as you can. Okay, so we have some folks who are not from DC, and they're asking what general laws they should follow. So yeah, a lot of today's presentation is based on provisions in the DC Nonprofit Code. The Nonprofit Code in DC is based off the Model Nonprofit Code, and a lot of the issues that we discussed today will be applicable in other states, but you should consult the Nonprofit Code or the Nonprofit Corporations Law of the state that you reside in to see if there are special requirements in the state that you're from. So yeah, today's presentation, just about DC. Check with your local state's requirements to see if there are different requirements. Okay. So we have a kind of specific question about a conflict of interest transaction. I think this will be one that we can discuss kind of off-site about whether this specifically qualifies as a conflict of interest. Conflict of interest is definitely one of the most tricky areas and something that can be very fact-specific. So again, if you need more resources on conflict of interest, check out our Serving on the Board of Directors section on our website. But this question about a specific conflict of interest situation, maybe that's something we can discuss offline. Okay, and we have another question about whether Virginia law are in concert with DC law. The answer is in a lot of situations, yes, but that's something that we would have to look into specifically for what might be different in Virginia. Let's see here. So if the board votes over email, should the secretary or a designated person attach each board member's vote as an attachment to the most recent meeting minutes? So in terms of terminology, we're talking about, again, unanimous written consents. We want to talk about them that way instead of just calling them votes, because they are distinct from traditional board voting in that they have to be unanimous. And so, yes, the nonprofit is responsible for collecting and storing all the unanimous written consents in one place to show that it was in fact unanimous, to show that you did in fact get responses from all the directors. Going back to the question, yeah, you can review and approve. You can ratify the consent at the next board meeting, But under DC law, it's enough if you just sort of satisfy the requirements for the unanimous written consent. That in and of itself is an action of the board. Let's see here. You need to record the name of the person who makes the motion and seconds it. That is something, that is information that you should include. Let's see here. It's possible to get the slides. Yeah, we have, let's see here. Okay, we have another question about unanimous written consent. For unanimous written consent, any notice requirements. Your bylaws can include additional notice requirements for unanimous written consent, so that's on an organization by organization basis. And of course, the consent itself needs to have a resolution or some information attached describing what the organization is voting on. So that kind of handles the notice issues, because in order for a director to respond, they have to review and kind of be appraised of what's in the consent itself. So that's usually addressing that issue. If we want to document the details of our meeting discussion, can that be done in something other than the minutes? And would that additional documentation also be discoverable? So yeah, everything related to your meetings can be discoverable. So just calling it something else that's not minutes doesn't shield it from being discoverable. So we mentioned earlier that the recording secretary or the secretary could take pretty detailed notes of the minutes to help, detailed notes of the meeting, to help them prepare the meeting minutes. But we also recommend that those notes be destroyed systematically after the minutes are prepared, because those notes could still be discoverable in case of litigation. So there's no kind of good workaround. Anything that you record and that you don't destroy, there is a risk that those documents will be discoverable. That's why keeping things brief and succinct up front and destroying notes and other things that are more detailed, it's really important process for your board. What if previous minutes include the names of board members? Should we go back in time and amend those minutes so that they don't have that information in it? That's up to the board. You could go back and vote to amend your minutes. That is a decision that the board can make. You might want to consider the extent and how far back you would go. But we would definitely just recommend changing your process going forward in either case. So, okay. Let's see here. What else do we got? Okay, so I think those are all the questions for now. Let me do one final check. Okay, great. So if people have additional questions, again, they can reach out via email. Thank you so much for attending today's session. Enjoy the rest of your day. Bye all.